you ready?
Yes, sir.
All right, we'll go ahead and get started. Hey, thank you all for joining us this afternoon for our Board Member 101 training. This is something that Adam and I have committed to doing on a quarterly basis to really get new board members and even existing board members who've been in the role for a while, just a refresher on everything you need to know to be successful in the role. There are a lot of things that get thrown at you as a board member of a community association, from statutory language that you need to be aware of, to what the governing documents say, to the operation of an association, and everything in between. And so this course that Adam and I have put together will take you through kind of a journey over the next hour and a half on just a little bit of what you need to be aware of, and hopefully will help get you started down the path of serving your community. And we're delighted to have you. Hey, my name is Mitch Kraus. I am the Chief Operating Officer here at Goodwin & Company. And I am very thankful for the opportunity to get to know you. I will, after our presentation today, we'll send you copies of the slides for you to have, as well as make my contact information available, as well as Adam's contact information available should we be resource to you. And anything that we can do to help facilitate this learning will be available to you, and would love to connect with you. And Adam, you want to introduce yourself to the group?
Thanks, Mitch. I appreciate it. My name is Adam Pugh. I'm an attorney specializing in the world of HOA law. I'm with the law firm of Cagle Pugh. Been doing this for about 16 years, and I'm just as happy as can be to be here. A lot of what I do is handle litigation for homeowners associations, and I've got more than enough. And so hopefully some of these tips can keep you out of litigation. That's my goal for all of you. And we've got a good group today, and I'm going to try to answer all your questions certainly at the end. But if you use the chat function while I'm going here, and you have questions you don't want to forget, just type them into the chat feature there. That'll pop up on Mitch's screen, and if it makes sense to interrupt the presentation and answer it right there, we'll be happy to do it, or we'll just wait till the end, but we'll make sure we get all your questions answered.
Yeah. All right. Sounds good. So Adam, thanks again for joining us. Always a pleasure having you on, and you're a wealth of knowledge, and appreciate all that you do to take time out of your busy day to join us for these enrichment courses. For those of you who are new to our webinars, just wanted to make a note. Adam and I have partnered with a bunch of on a bunch of these in the past, and the goal is really once a month at a minimum to try to put out new content. I know that there's a lot of hunger out there for more knowledge on given topics, and we try to take some of the hot topics out there and bring them to you. So we've had conversations around COVID-19 when all that was going on and all that was new, and how that affected association operations and amenities. And we've had a number of different topics in between, how to run effective meetings, the whole nine. So there's about 20 or so that we've now done over the last couple of years, and those are all available for you on our Facebook page at Goodwin & Co. And again, I'll be sending out a copy of the presentation, and we'll send you a link to where you can access some of this content should you ever need it. Wanted to, before we kind of dive into Adam's piece, just wanted to orient you, our new board members, on some resources at Goodwin & Company, and what to do with that information. One of the things that I would call an essential resource is TownSq. TownSq is our homeowner management and board portal. It syncs with with our accounting software and with other systems that we use, and serves as kind of a hub for information on communicating with neighbors, sending out notices to the community about what's going on, whether it's events or meetings or whatever else. It's a very highly customizable tool, and something that we continually try to get training out to you. We want that to be your tool. It's something that we want to make sure it works for you. And so if you're ever interested in taking a deeper dive into TownSq and kind of looking at all the bells and whistles it offers and learn a little more about what's also coming down the development path for TownSq, we encourage you to please reach out, let us know, and we can set up some training and talk about just some of the different features that we can turn on if you're not already making use of those. But one of the things that I also on TownSq you'll note is TownSq is a place where we deliver our financial reports. So you'll have, so we just sent out our financial reports for the previous month yesterday on the 15th. And those are available to you. If you are a new board member and you don't have access to seeing those financial reports, please let us know and let your community manager know, and they'll make sure that to get you access to that. In TownSq, we assign you into a board group that gives you permission and viewing rights into other items in TownSq that the general population typically doesn't have access to. So please let us know if you can't find those. Also available on TownSq, governing documents. I'll talk a little bit about just manager assignments as a tool that helps to keep us all organized. As a board member, you'll have access to homeowner requests and you can see those. We can also turn those off if you don't want to see it, but we're always err on the side of transparency and make sure that you see how we're answering those and how quickly we're answering those. There's also an opportunity for you to post polls and engage the community on different topics or items that you're considering or weighing to vote on. And also an opportunity to, there's a couple forums and places where you as a board can communicate and try to keep things out of email if you want, and just kind of keep a flow of conversation. So there's all kinds of cool features available in TownSq, and I'll highlight a couple others in a couple minutes. There's also access to a board portal. The board portal is a basically connection through Village Management Software, which is our accounting software. And as board members, we give you access into being able to pull live financial reports and other operational reports. There's about 12 to 15 or so reports that are pulled right out of the back end of our accounting system and available to you at all times. So if you want to run a balance sheet on any given day and not have to wait just for the static month-end report, you can do so. And you can see what's going on from that standpoint. You can run a general ledger query and see transactions that have flowed between reporting periods. So those are available to you. And again, if you would like access to that, haven't received your invitation to the board portal and accessing that, please let us know. Let your community manager know. There's a form internally we fill out, and that lets our support team know to give you access to that. And then we'll send you an invitation with an email that will have all of your login credentials. And the other essential resource we want to make sure that you're aware of as a new board member is that aside from your community manager, we also have a large team here to support your community manager. So while your community manager serves as kind of the day-to-day contact, that community manager is also supported by a director of community management and a now newly added senior vice president of community management. That's Chris Larson and myself. And so we've got a team here, and our leadership team is here to support you. So always want an opportunity for you to build a relationship with, not only with your community manager, but the rest of our team. So if there's ever anything that we can do to support you, again, please let us know. Couple communication tools that I wanted to make you aware of as a new board member. And these are just some things that I think might be helpful. One is just from an organizational standpoint, you'll see this assignments screenshot over here on the left. Assignments is a tool in TownSq. It's actually going to be getting a little bit of a refresh here in the next couple months. Excited about that. But what that is an opportunity, as board members, depending on how hands-on you are, there's always a to-do list, right? Your manager's working through and trying to knock things out. And especially on our end with working with 5, 7, 9, 11 board members in some communities, there's a lot of different things that are flowing through email and through different avenues in terms of things that we're working on. And sometimes that gets a little chaotic in managing all of those. So just a helpful tool if you're interested in using it. It's something that I promote quite a bit of. Is this assignment section in TownSq that allows you to kind of have a running to-do list. It allows us to set expectations around things like due dates, status of whether we are, something hasn't been started yet, whether it's in progress or whether it's complete. Gives you the ability to filter by those items, allows us to add attachments to those items, and also a place where we can comment back and forth on those items. But really helpful place to be able to organize and prioritize what it is that we're working at any time. And it also helps us as our leadership team to be able to track how we're doing, making sure we're meeting our commitments. And if there's anything that we're falling behind on, making sure that we're lending the resources to be able to support moving those things forward. So encourage you to check that out. If you're interested in learning more on the assignment section, let us know, and we'll be happy to put together a training on that. There's also a board member forum. It's actually a general forum. The forum allows for homeowners to collaborate. It's kind of our answer to social media, right? A lot of communities have these kind of rogue Facebook pages. Some are very well organized, and board members contribute on those in terms of just kind of connecting neighbors and communicating what's going on in the community. But we also have in TownSq a forum section. For those of you who are interested in learning more about that, you can create custom categories. But one of the things that I just wanted to call to your attention is that if you're interested, there's a place on those forums where you can create private forums, and you can basically get the board group together along with the manager if you're interested, and a place where you all can share correspondence, share documents, and just kind of capture conversations that are happening. Nice thing about using those forums is it kind of just removes it from email, and also kind of creates a history of those ongoing conversations and communication across the group. And the nice thing about that is that if there is ever a board member who's coming in and replacing a seat, they can kind of jump in and reference something historically in that forum. So just some helpful tools. Do what you'd like with it. But I just wanted to make sure that I was featuring those as just some tools that you may or may not be taking advantage of today. TownSq also has the ability for us to share news and events. We try to send kind of a multi-pronged approach when we are sending out a message. We can send out an announcement via TownSq through the announcement section. We also typically will send a separate email and create some redundancy there so that we capture folks who are both engaged in TownSq and also on via email. And that could be anything from an upcoming event that's happening in the community, or something, for those of you who are in the condo world, hey, we're going to shut down a stack, water in a stack in your condo. And so, here's an announcement, and we can post that and let people know. The more folks that we have engaged in TownSq, and the more that are using the mobile application, the quicker that they'll get those notifications. And something that's been a really nice feature is that now we can gauge how many homeowners are seeing our communication as they're going out. So that's been pretty helpful. There's also a website feature that many of you may be aware of. It's something that is highly customizable, very easy to customize via TownSq. You can go in and modify and add content to your website, and we can even buy a custom domain and link that to your community website. So for those of you who are out there that are interested in kind of playing with that or using that as a tool, I really like it. I like the idea of having, buying a domain, being able to point someone to, abchoa.com, and have that be kind of the starting point for all association communication. And then also being able to have a login section where folks can log in and dive deeper into the TownSq functionality for homeowners specifically. But that website's being used very well by many communities, and not so well by others. So I just wanted to take a moment to let you know that from a communication standpoint, I know many of you have an important objective of trying to create and enrich the relationships within the community and bring people together. These communication tools, hopefully you'll find to be helpful in being able to do so. The other thing that some other things that you're able to do, surveys. You can create custom surveys and kind of get a pulse of what's going on in the community. One of the things that we're also working on right now is electronic voting through TownSq, which is pretty cool. There's some modifications being made, but that's something that we will be facilitating hopefully here in the near future. There's also a pretty significant document repository. It's where we add our financials, governing documents, and other items. And also the document section in TownSq allows you the ability to take a certain category of documents and move them to your website. So that's a helpful feature as well. And one new feature, and something that we'll be talking about on another webinar tomorrow, is our architectural review feature. And that is a really helpful tool that has gained a ton of popularity here in recent months and really over the past year. We've seen the number of architectural requests increase, I don't know, tenfold probably over the last year. Over the last couple of years, especially as we were all kind of confined to our homes through COVID, a lot of improvements being done to homes and communities. And so TownSq answered the call with building out this new architectural review feature. Really helpful, allows us to create all kinds of modified forms, electronic forms that we can use on a per project basis, allows a homeowner to complete those forms very quickly and efficiently, submit that for the architectural committee reviews request, review, and we can deliver a verdict letter in TownSq. So all kind of end-to-end communication around facilitating the handling of architectural review applications and making it easy for you to archive those applications as we go. In the board update and invitation that I sent out this past week, if you look at the body of that email, you'll see a video that TownSq put together that kind of walks you through a demo of that tool. So if you're interested, check out that video, and you'll be able to see kind of how you walk through that feature and how easy it is to be able to navigate that and keep all that historical information all in one place. So I encourage you to check that out when you get a chance. One of the things as I transition to just a couple things that I think is helpful for new boards, especially when you've got multiple new board members and you're coming together as a new team, is really encourage you to come up with a game plan. And this is something that we always want to partner with you on. But you run any business, and one of the things that you'll hear us say over the course of today's training is that we are really running a business. When as a board of directors, we often forget about the fact that our community associations are a business, and just like you'd run any business, and many of you are running your business or part of a leadership team in your business, and you've got your objectives that you set out to accomplish. And many of us run for a board, or sometimes we're begged to join the board, but many of us join the board for a reason, right? We want to improve the situation. We want to make it better than the way we found it. And one of the things that I encourage you to do, especially to create some cohesion amongst the team and to create kind of a clear focus as to what you want to accomplish over the course of the year and over the course of your term as a board member, is that you think about developing a strategic plan. And a very simple mechanism for that is something that has spread in popularity across many organizations such as Google and other organizations across the world, is this concept of OKRs. It's something that we use as an organization in crafting our strategic plan each year. And we look at and study every quarter to see how we're performing. OKRs are a very simple way of creating objectives, and objectives are something as simple as saying, we want to create a community that is fiscally responsible and financially stable, right? And so if that's your objective around being financially stable, then you create some key results. And what are those key results? Those key results are just measurable things that are going to feed that objective of becoming financially stable. And so you might set some key results that include a target for past due assessments, right? A number of homeowners who are past due. And so maybe we want to reduce the count by 5% going into next year. And then as you create that target, that allows us to be able to say, okay, what can we do to impact that board's objective? And that might be, reviewing the way that we are collecting on past due assessments, or creating a campaign and awareness around the billing process, and making sure that we're communicating with homeowners about potential repercussions of not paying their assessments on time. So that's just one key result, right? Another key result might be something as simple as, if you've never done it before, creating or having a reserve study completed. And that reserve study will allow you to create a roadmap for what you need to do to have long-term funding to accomplish or tackle some of the larger projects that you'll have to accomplish over the next year, 3 years, 5 years, and beyond. So the idea of creating this strategic plan is one that I would encourage you to get together as a group. This is a perfect time of the year to do that. And it's something that if you're interested or want to learn more about ways to do this, I'd welcome the opportunity to connect with you and talk through that with you. The other thing I wanted to just highlight is just a reminder of, and this is something that I adapted from the Community Association Institute's board member toolkit. This is just kind of the qualities of a good board member. And there's, from a mindset perspective, as you join your board, I've seen it all, right? And Adam's seen it all. You've got board members who join for a very specific purpose and want to accomplish that purpose, and then want to get off the board. But more often than not, we have great board members who kind of bring that servant leadership to the table and are thinking about the needs of others before their own. And so I always love this little visual of what are some of the qualities of a good board member, and and contrast that against what an inappropriate board member does. And a good board member is one who's of good character, strong integrity, calm judgment, a willingness to serve, committed to the best interests of the community as a whole, have relevant experience or background, previous volunteer service, and strong people skills. An inappropriate board member, or someone who may not be better suited to serving their board of directors, is one who's unable to put the welfare of the community first, works behind the board to run things his or her way, impulsive or quick-tempered, has a personal or hidden agenda, puts individual interests first, has little or no experience in management, leadership, or service, unable to work with others for the common good, and poor interpersonal skills. So, something that I just wanted to float out there in terms of, defining who you are and what your purpose for being on the board of directors is. And, the one thing that I will leave you with on this thought is that as a board of directors, there are going to be times, especially if we got 3, 5, 7 people that we're interacting with to make decisions, there are going to be times where we feel very strongly about moving a certain item forward. And you might have a section of the board that has a different viewpoint on that. And very much like government operates, this is kind of a democracy here. There's going to be a world where the majority is always going to win, right? And sometimes if you're not careful and we dwell on, hey, I really wanted to get this done, I couldn't convince the others to do it, and now I'm upset about the outcome of that. Just know that there's also going to be situations where those things are going to pass, and you're not going to be on the winning side, quote unquote, of moving that forward. The big thing is that you recognize that there are going to be times where we have difference of opinions on things. And I would encourage you to just live by the principle that that's okay, right? The idea is that we need to be accepting of all viewpoints, and there are going to be things on our agenda that are going to pass. There are going to be things that aren't going to pass. And the big thing is that we be respectful to those opinions when they differ. That goes a long, long way in the dynamics of a team, and making sure that we're working together for the good of the community. Because when politics gets in the way of things, it makes it very it can turn into potentially a very ugly situation. So just a good reminder, something I like to share as you venture down this journey of joining your board of directors. One of the things that I wanted to share, and this is going to take on maybe a different form across many different groups, and that is just kind of the role of board members. And so typically, and I'll say typically because every community kind of takes on its own, has its own culture and has its own way of doing things. But typically, as you join the board, you're given a role, and that could be kind of one of these officer roles or a director at large role, depending on how big your board is. But the structure is typically one in which you've got a president, and that president is kind of the lead for the group. This is someone who usually is one who is entrusted in speaking for the board and the association. This is someone who we typically will work with specifically in providing direction to management. This is pretty important sometimes because we've got situations where we might have 7 board members and 3 agree on something, 3 don't agree on something, and sometimes members of the board might be vying or sending the manager in down different paths, right? One group says, hey, this is a priority, this needs to get done. And then the other group says, hey, that's not a priority, this needs to be done. And unless we have one person who's kind of leading the charge on saying, hey, this is where we want you to spend your time, it can start to get very difficult to manage. And so typically the president is entrusted with being kind of that mouthpiece of the board of directors and providing clarity as to what those objectives are and where to spend our time. There's also the vice president, who typically substitutes for the president in their absence, and oftentimes, very much like the way our government is set up, may be someone who runs point on committees and might serve as a contact to one or all committees. Sometimes I've seen boards who also have a very specific committee. If you have committees, many of us don't have committees because we just don't have enough people to participate in those committees. But I love the situations where you've got a board member who kind of leads a committee, and then that person serves to both provide oversight over that committee and also serves as a contact point as a representative of the board for items that committee is working on. Secretary is typically the official keeper of the association's records, and also someone who's typically tasked with ensuring the proper communications are out. It's a lot of what you delegate to us as well as your management team. And then you've got your treasurer, who's we call the CFO of the association, the chief financial officer. That's someone who's serving as another set of eyes over the financials, making sure that we're producing accurate financial reports and being kind of a steward to the rest of the board on where we money management and having a deeper understanding as to what we need to do in order to get proper funding to accomplish a certain project or task. One of the things that I'll say to this, and you'll see the little quote, the difference between a resident and president is a P. There's really not a whole big difference. One thing that I'd encourage you to do and this is something that Adam will go into in a little deeper, the one thing I will encourage you to do is always operate transparently. Oftentimes, just because we have a role on the board of directors, we're all the same, right? We all have the same, we're all stakeholders in this community. And while you'll have access to more privileged information about the operation of the association, as you should, just know that every resident in the community is important. And when you're adopting the right mindset about serving your board, just know that the title shouldn't always mean a whole lot in terms of connecting with your neighbors and doing right by the association. A quick note about the role that we play, and I always like to just cover this briefly about what is the role of management. And in the ideal sense, we are coordinating and supervising the maintenance activities. So we are managing the common areas of the association, and we are serving as a point of contact to the association's vendors and professionals, and making sure that things are getting done on behalf of the board. In the best sense, the board sets the strategy and management executes on that strategy, right? We alert the board when legal assistance is needed. We advise of regulatory issues and compliance requirements. We do a lot at Goodwin to make sure that our managers are up on legislative changes and statutory changes, and they become experts in understanding the governing documents. But at some point, there's also a point where we're not attorneys. And so we've got to make sure that we work with folks like Adam to make decisions that will mitigate risk for the association. We also coordinate member and board communication. We manage the association's finances. We handle the books and also the governance aspect. And so we'll administer violation letters and everything else from that standpoint. We provide oversight and coordination of vendors and professionals, as I mentioned earlier, and then manage compliance with the governing documents. Between the board and management, so again, the board makes decisions and sets policies. At no point will we ever make a decision about a vendor that you're to use. You are the boss, right? And in this relationship, you are the boss. We take direction from you. What we will do is provide our experience and knowledge and make sure that you are, when there's something out to bid, that we will work with the board and rely on our experience to be able to help you select the right vendor based on our experience, or make sure that you're going about it the right way. And one thing that's a major expectation of the board is that you reach a consensus on policy and direction, and then that allows us to go ahead and carry out those functions. On management's end, we implement the board directives, right? We execute on those objectives. We work with the board president to fulfill the policy of the board, and we serve at the pleasure of the board. And again, that's important that you know, because if there's ever a situation in which you feel like we are dictating what or in contrary to what your objectives as a board are, we want to know about that, right? We are here to serve. We are not here to dictate. And so in all cases, if there's ever a situation where we can help or look at things a little differently and facilitate an easier way of doing things, we're here to do that. From a financial management perspective, I mentioned this earlier, but just wanted to make you aware, we deliver your financials on the 15th of every month. We try really, really hard to stick to that date. Sometimes it's a day before, hopefully, but we try to commit to getting it out no later than the 15th. When we do, we will submit that package to you via email, or I'm sorry, via TownSq, and you'll receive your financials in the document section of TownSq. As you log in on the 15th of every month, you should see in the timeline that those documents have dropped. As I mentioned earlier, live reporting is also available in our VMS portal, and you can run those reports whenever you want. And you can set time parameters on those reports as well, which is pretty cool. Our package of financial information consists of our financial statement, which includes your balance sheet, your accounts payable section, which also includes copies of every invoice paid during the period, your accounts receivable, which gives you all of the details around both prepaid assessments and also past due assessments and the management of that. Your general ledger, which records every transaction that makes up your P&L, and a bank reconciliation, which includes all of your bank statements for that period. And one of the things that we are working on right now, and that we started probably actually around July this year, is the budget process. And so everybody should have received by now a copy of your budget. That is something that we're actively working on now, converting that into billing for the coming year. So if the assessment amount changes, we are working on getting those finalized, getting those passed, and getting that moving. I've got a snapshot of the monthly board update that we send out, and you should have received the most previous one in the invite for today's webinar. But for any reason, if you're just kind of learning about this, we may not have the right email address for you. So please let us know, and we'll make sure that we send out that update to you. But that update consists of just everything going on at Goodwin, things that you need to be aware of, training opportunities, new tools made available, and we try to get that out pretty consistently each month. All right. Well, that does it for the Goodwin side. I do have a couple questions. and the light just went off in my office. So I will just answer those real quick. First question is, do board members have administrative rights in Town Square? And the answer to that is yes, Lynn. You should have administrative rights in Town Square. Board members are set up by default to have the exact same administrative rights that we do. Let me just wave those lights. There you go. Again, if there's interest, when I send out that email, you have my contact information. Let me know, and I can match you with Fred on our team here, who is kind of our subject matter expert on Town Square, and can set up some training with you and your board and walk you through what you need to know about that. Another question is, within Town Square, is the standard to update the status of homeowner requests as the request progresses? Yes, the standard is that. So when a request comes in through Town Square, what will happen is that our customer care team will try to resolve that question or that request as quickly as possible. And if not, if they don't have the answer to that, it needs to be escalated to the manager or to a different department, they'll go ahead and assign that request to that specific department. And so as you're looking through those requests, know that you're not required or expected to touch those. We want you to just be aware of them in the event that you want to see how we're responding to things. But it is not the intent for you to address those. Our customer care team will try to route those to the appropriate party and then resolve those from there. Question from another board member: how does the board treasurer get confidence that the financial reports are complete and accurate? That's a great question. Best thing is, one of the things that we could do is sit down with your community manager and be able to spend some time just kind of going through it. Oftentimes, just even understanding I recognize that sometimes board members are new to the role of kind of reviewing a P&L. If you're not doing that on a regular basis at work, some of that might be a little bit foreign. And so kind of breaking that down and offering some insight on what goes into your financial statements and all of the transactions that are happening is a necessary activity. And so having kind of an orientation around that, I think, would be really helpful. Ultimately, one of the best ways to gain confidence around the financial reports being complete and accurate is a third-party independent audit. And that's something that isn't a requirement, but is a best practice each year. Many of our associations will work with an independent CPA to review the financials and perform an audit of those financials. And then that way the board knows that we've done what we have to do regarding the financial picture of the association. So that might be something that might be helpful if that answers your question, Lisette, and happy to take that offline if you have more questions. I'm going to go ahead and segue to Adam. I've got a copy of all the questions, and I'll make sure to respond to you each individually if I don't get back to a question during this time. But wanted to move on with the rest of the presentation, and we'll get back to those questions in a minute. Adam, thanks for patiently waiting on the Goodwin piece.
Well, I appreciate it, and I think all that's very important, and I think it sets the stage for some of the legal responsibilities that are set up by statute and common law, and we can just go ahead and dig into that now.
Yeah,
that's just my name.
Yeah.
This is a little cartoon that we like to use. A lot of times board members are not very excited about change in the neighborhood and want to do things the same way all the time. And as we've learned in this last legislative session, that's just not going to be feasible. And so sometimes we have to change with the times, sometimes we have to change with the legislature, and sometimes there's some impetus in the community to make us change, but we have to be flexible and willing to change from time to time as these kinds of things come up. So as a member of the board of directors, you're in a group that is going to be consistent across the landscape. So almost all Texas community associations are managed by a board of directors. It's generally responsible for setting the goals, standards, and policies of the association, as Mitch discussed with you. You're also responsible for enforcing the governing documents, maintaining the common areas or the common elements, and entering into contracts for services on behalf of the community. That's the simple outline, but it gets a little bit more complicated. Now, what I've done is I've broken down your roles and responsibilities into what we call the 6 C's of community associations. And that stands for contract, corporation, compliance, collections, covenants, and community. And we're going to address all of those as we go. And so the first one is contract. So a community association is a private organization. You're a nonprofit association governed by the laws of the state of Texas, and you exist based on an established written contract, generally called the Declaration of Covenants, Conditions, and Restrictions. In a condominium, it probably has the word condominium in it. And your association will be made up of property owners in what we call a common interest development. You'll be vested with the management and maintenance of the community and its amenities or commonly owned property. And this is all governed by your declaration. You'll probably hear me say more than enough times today to review your documents. And the first document is the declaration. It's recorded by the developer in the local official public records of the county where the community is located. The declaration is a covenant which runs with the land. And that's just kind of an old-fashioned way of saying that these covenants apply to whoever the owner is. And so whether or not you've signed a piece of paper, whether or not your real estate agent handed you a copy of the declaration the first time you walked through that home, you are bound by that document just as if you executed it and signed it yourself. It constitutes a private contractual agreement that imposes certain obligations upon the owners of the property subject to the declaration. And so that's going to include everybody in the community along with the association, and it's just a contract, and so you've got to know what it says. Now, there are 3 categories of contractual obligations that you'll be responsible for as a board member. You've got the obligation of mandatory membership in the community association. There's the obligation to pay assessments levied by the association. And then, of course, the obligation to comply with the applicable land use restrictions. And sometimes we'll refer to those as restrictive covenants. Now, the declaration, as I said before, is the most important part of the community association governing documents, aside and apart from the association's certificate of formation. It will generally trump any conflicting provisions in any of the other governing documents like your rules, your bylaws, ACC guidelines. The declaration is kind of like the constitution of the association. We can go ahead and go to the next slide. And so that covers really what you need to know about contracts. Now we can talk about the association as a corporation. Now, almost all Texas community associations are incorporated. There are still some stragglers out there under Section 81 of the Texas Property Code that are unincorporated nonprofits, but that's getting rare and rare. Texas nonprofit corporations are governed by their corporate governing documents, and this includes the Certificate of Formation, also known as the Articles of Incorporation, and its bylaws, along with, of course, Chapter 22 of the Texas Business Organizations Code. And like a corporation, it is established by the Certificate of Formation. So you find the name of the nonprofit in your Certificate of Formation. You'd be surprised how many associations have decided to call themselves something that's either shorter or different than what their legal name is. It doesn't take very long to check. I'd encourage all of you, just take a peek at your certificate of formation and know whether or not you're using the correct name. The certificate of formation will also tell you the purpose for which the nonprofit corporation is formed. That's generally some boilerplate language, but you might find, if you look, some limitations in your power or some obligations that you might not have been aware of. So I'd encourage you to take a look at that. And it also will tell you whether or not your corporation is to be managed by a board of directors or the members. I'd take a look at that as well. From time to time, lawyers who do this will check the wrong box. And if they checked the wrong box and you're not supposed to be governed by a board of directors and you're on the board of directors, we probably need to talk. But the good news is it's an easy fix. But take a look, make sure you're abiding by the certificate of formation, which is sort of like a corporation's birth certificate. Now, the bylaws generally provide for procedures for the internal governance of the association, things like the number of directors and officers and their terms of office, the election and removal of directors and officers, the time, place, and procedures for regular and special board meetings, and the time, place, and procedures for regular annual and special membership meetings, which are different from board meetings. And of course, it will talk about the procedures for the amendment of the bylaws if you have the desire to change the number of directors or officers or the place for your meetings. All right, so the third C is compliance. Now, all community associations should be managed in compliance with their declaration, the corporate governing documents, and of course, applicable statutory laws. That's Chapter 22 of the Business Organizations Code, Chapter 81 or 82 if you're of the Property Code if you're a condominium, or Chapter 209, and then of course 202 and 204 if you're a subdivision association. Compliance also, we can go to the next slide. Compliance will also refer to Chapter 209 of the Texas Property Code. This only applies to subdivision associations. It's known as the Texas Residential Property Owners Protection Act, which is a mouthful. It's a regulatory statute. It doesn't give a subdivision association any particular powers, with very few exceptions. What it does is it limits the powers that exist in your governing documents, specifically your declaration, and it trumps any conflicting provisions in the declaration or your corporate governing documents. For instance, 209.0041 of the Texas Property Code says that if your declaration requires more than 67% of the owners to amend it, well, then the number is 67%. And so it actually limits what you can do in your association. Now, we also have chapters 81 and 82, as I mentioned. These only apply to condominium associations. 81 and then parts of 82 apply to condos that were created prior to January 1st, 1994. Chapter 82 applies to everything else. Now, Chapter 81 and 82 are empowerment statutes, and they actually will fill in the gaps when condos were set up without all the necessary powers. Things like fining its members are found in Chapter 82. And so even if your declaration does not authorize you to fine your members, Chapter 82 does. And there's some other rights that can be found in there as well. So it's good to just take a look at Chapter 82. I'm not suggesting you read every word or memorize it, but if you just take a look at these chapters and see how they're organized, see what the topics are that they refer to, then when one of these issues comes up, it might refresh your memory that, hey, maybe we can go check the code, and that might give us an answer. But of course, if you've got questions about these issues, our firm's always available to answer those questions. And there are very few regulatory provisions in Chapter 81 and 82, meaning there's very few restrictions on what you can do as a condo association. If it's in your declaration, chances are you'll be able to enforce those obligations on your members.
I will say, Adam, that for those who are new to their board and just, they're going reference, Chapter 81, 82, or 209, You can't always do the eye test in your community to determine whether you're a condo or an association. And sometimes the governing documents don't specify that very clearly. So when in doubt, I've seen many an argument brew or debate brew when someone's quoting one section of the property code and someone's quoting the other section. And so what may look like a single family homeowners association might actually be a condo, might fall under the provisions of chapter 81 or 82. And so that particularly gets kind of odd when you have the townhome type communities or garden style type or villa type homes, and which one it pertains to is something that is something that you want to make sure that you're clear on, because nothing like spending time researching a statute only to find out that it is not the correct one, right?
Absolutely, and it raises a good point. And at the beginning of my career, I found it a little bit humorous when folks would come in and they wouldn't know whether they were a condo or a subdivision association. But I think that just speaks to the way sometimes developers exit stage left. But I'll give you a very quick rule of thumb. If your deed to your property includes an undivided interest in and to the common areas, you're in a condominium. And that's really the best way to figure it out. And that's how I usually do it. Sometimes the declarations aren't clear and they don't make it easy to figure it out. Usually if the declaration contains the word condominium, it's a pretty good clue, but sometimes condominium declarations don't use that word, which is baffling to me why a lawyer would hide the ball on what type of entity you are. But it still happens, and we get that question about once a month. But that's a good point, and I'm glad you brought it up.
One thing I always mention as well is for those of you who are on the board of directors of communities that have been established now for decades, every 2 years when the legislature meets, there's usually some update that impacts the way that we govern subdivisions and condominiums. And so things change, and sometimes those things are contradictory to what your governing documents say. And so one of the things that I'd encourage you to do is if you live in a community that has now been operating for many, many years, may not be a bad idea to consult with your legal counsel about just kind of an update. And some of those things are easy enough for you to update through board resolution. Sometimes those are difficult to do, requiring a majority interest of the members of the association to make those amendments. But in any event, there's, it's one thing when you're reading the governing documents and then the statute contradicts that. Just something to think about. And also just the needs of a community association tends to evolve. What was important in the 80s in some cases is not important today, right? And so oftentimes we always go to the source, and that's the governing documents and what the governing documents say. But some of that may not be consistent with what the reality is of today's environment, and also might be something that keeps the community from being more marketable in terms of homeowner values, right? So especially when it comes to very restrictive policies around rentals and other items, those are things that might behoove you to review and look at kind of an update of your governing documents.
It's a good point. Very good point. So one of the other areas of compliance that you need to keep in mind as a board member is that you are required to comply with Texas nonprofit corporation law. Specifically, that's chapter 22 of the Texas Business Organization Code. And it applies to all community associations that are incorporated as nonprofits, which I would stand to wager is everybody on this call is part of a nonprofit organization. The nonprofit corporation law, chapter 22, is a gap filler statute. So if your bylaws don't address certain issues, then chapter 22 will generally control. There are a lot of provisions of 22 that indicate that unless your bylaws state something to the contrary, then the following applies. And so your bylaws can conflict with Chapter 22 and control in some instances, but to the extent they're silent, Chapter 22 would control, and provides default rules in the event that an issue is not addressed by your corporate governing documents, which of course include your bylaws and your articles of incorporation, in some very limited instances, the declaration. So the fourth C is collections. And I know it's not always an exciting topic, but it's one that we deal with quite a bit at our law firm. We have a whole division of our firm that is devoted to collections. We generally refer to them as the payment plan folks, because about 99% of the time what they're doing is negotiating with owners to enter into payment plans. And if we go to the next slide here, it's important to remember that Texas community associations provide essential services to their communities. In fact, for the most part, the reason why homeowners associations have become so prevalent is because of the Clean Water Act of 1972, which required developers of communities to manage the flow of water through the community. In essence, water that comes into the area that's being developed is supposed to exit just about the same way it did before all of that impervious cover was installed. And in order to take care of these drainage easements and ponds and other facilities that are required to comply with that act, developers started to implement homeowners associations, which could, in essence, live forever and levy assessments in order to maintain those assets. And so almost all community associations are authorized to levy assessments. Otherwise, you wouldn't be able to provide these essential services. And the authority to levy those assessments has to be established by statute or your declaration. And almost every declaration for a mandatory homeowners association will include language that allows for a lien and foreclosure in the event that those assessments aren't paid. So we can move to the next slide. And your declaration will generally establish the types of and procedures for levying assessments. That usually means regular and special assessments, but there's a new kind of modern approach where we've got 5 or 6 different categories of assessments, where we call what we used to call fines. Sometimes we call those individual assessments. And the purpose of doing that is so that those assessments are secured by a lien on the property. Now, these provide that the obligation to pay assessments is levied is a personal obligation of the property owner, meaning if they don't pay during the period of time that they own the property, they can be sued. And it also establishes a lien in favor of the association to secure the payment, which can be foreclosed on if the owner doesn't pay. This is the biggest tool we have in our toolbox. Generally, a lien against somebody's home is significantly outweighed by their equity or their desire to be there. Usually, these balances don't get more than $3,000, $4,000, sometimes $5,000. But generally, folks will find a way to enter into a very reasonable payment plan to pay back that debt once they're educated on this lien and how it can be foreclosed. For condominiums, a lien in favor of the condominium association is established by Chapter 82 of the Property Code, even if your declaration doesn't mention it. So it's important to understand that you have the right to foreclose in almost every association. All right, and if we move to the next slide. Now, when property owners fail to pay their assessments, a community association has to engage in collection efforts to recover those unpaid assessments. And it's important to engage in these efforts in a very homogeneous way so that you are treating everybody equally. Now, these collection actions will include demand letters sent by the association. I know that Goodwin has a robust collection department that sends out demand letters in increments that gradually escalate in severity. The collection actions can include recording notices of a lien in the official public records. And then finally, as a last ditch effort, foreclosing on the lien. We almost never actually do that. Even when we file suits to foreclose, the idea is to get the owner's attention. And sometimes it takes a process server showing up Sometimes it takes the constable with an order of sale and his badge and authority to really get someone's attention. But at all times, even after the foreclosure sale, there's an opportunity for the owner to enter into a payment plan.
Adam, just wanted to talk a little bit about foreclosures in general. Obviously, that's such an important tool for a board of directors to kind of escalate the importance of collection act, right? And oftentimes I find in conversations with boards that they'll sit on these balances for a significant amount of time in the hopes that, hey, somebody sells their home and, at that point makes it right. Can you talk a little bit about just the idea around this foreclosure process when a file gets escalated to your office and you're to act on that? Why is that? I mean, obviously, nobody wants to take possession of someone's home. We've all read kind of the stories in the paper or news stories about how this big bad board stole someone's home. That's not the idea here. Can you elaborate a little bit about using that as a tool and why it's an important one?
Sure. Well, in almost every instance, the association has gone out of its way by the time it gets to our office to enter into payment plans, to remind folks of their obligation. And keep in mind, 90 to 95% of owners in community associations pay their dues every time, on time, and without demand. And your job on the board of directors is to serve the community. And when almost everybody in the community is paying their fair share, it's really a disservice to allow members of the community to not do that. And so, sometimes general reminders work, sometimes filing a lien works, sometimes reporting to credit bureaus works, but sometimes it doesn't. And sometimes it takes a little bit extra to get folks' attention. And that's where the foreclosure process comes in. It really is an educational process. I get so many phone calls and I get on the phone with these owners and they say things like, well, I didn't know you could foreclose, or I didn't join the association. And there's a lot of education that takes place. You have to explain that regardless of whether or not it was explained to you by the realtor, you're in a community association and you're going to have to pay these assessments. And if you don't, there's late fees. And a lot of times folks don't even know what their assessments go to pay for. And so just explaining to them what benefits they get, the idea that maintaining these, the common areas and enforcing compliance of these restrictive covenants, it helps maintain property values. And for most people, their home is their number one largest asset. And so to keep those property values high is really the purpose of the association and of those assessments. And so we try to take a positive approach to, we're not just trying to collect these big numbers and get the money into the coffers of the association. Ultimately, even the folks having to pay our fees, which are the owners ultimately, are contributing to a positive outcome for the association. And so that brings us to the procedure. And before we actually ever foreclose, there are so many contacts with the owner. They are sent demand letters. We send them certified and by regular mail in case they don't want to sign for it. They still get a copy. We call people back when they call our office. We talk about payment plans. We hear them out on their specific situations, and we try to accommodate even the most extensive requests. After they finally get personally served with the lawsuit, they've got another month approximately to respond. If they don't respond, the association can get a judgment and foreclose. But that's again a last resort. So after the judgment is entered, an order of sale is served on the owner. The constable will serve that. We'll encourage them to contact us. I have a cover letter that goes to the constable that pleads with these folks to please just call us and set up a payment plan. I've got a team of about 8 paralegals sitting by the phone, ready to talk to folks to enter into those payment plans. But even after a foreclosure, if people stick their head in the sand and ignore every letter we send, every lien that's filed, every lawsuit that's filed, if they ignore the constable when they show up at the door, if they ignore the notices that get duct taped to the door, if they refuse to answer the doorbell, and we go down to the courthouse and we have a foreclosure sale in a homeowners association, not a condo association, they have 6 months to contact us and redeem their property by simply paying what the association is owed all along. In a condominium association, it's 90 days. So even after we foreclose, it's not over, and the owners can get their property back. So it's a very long, drawn out process. Sometimes homeowners associations are very frustrated by how long it takes, but that lengthy process, all those checks and balances are to protect homeowners and to make sure that we're not accidentally foreclosing on somebody that just wasn't getting the notices, that we're not, missing some important person that needs to get notice. And so what that ends up resulting in are very, very few actual foreclosures down at the courthouse that result in anybody being dispossessed of their home. We avoid that at all costs. So that's a very long answer to your question, but it covers the whole process.
Adam, when so new board members coming in, looking at kind of their AR report for the first time, any ideas around is there a balance threshold? Is there a point at which we should say, hey, I need to reach out to Adam, or I need to reach out to, the association's legal counsel to escalate that collections process and try to really gain traction on that receivable?
Yeah, I mean, it really depends. The sooner the better. I mean, the quicker you can get to the foreclosure process with a problematic account, the more success we're going to have. It's very easy to solve a $500 problem. It's very hard to solve a $5,000 problem. And the only difference between those two balances in a community where everybody pays the same assessments is time. And so, you have to make the decision what's feasible. So if somebody owes the association $50, I'm not suggesting you file a foreclosure suit. But if somebody's getting, 90 days past due, more than $1,000 past due, I think there's really not even an analysis to do. You need to escalate the process and get it to our office, because it's just exponentially more complicated to solve a problem when the amount owed is higher. I mean, if somebody wants to pay $50 a month to solve their delinquency, we can do that if they owe $500. If they owe $5,000, it's going to take them 10 years to pay off the balance. And my experience is anything over 12 months on a payment plan is destined to fail. We have a very, very low success rate with anything over 12 months. Anything under 12 months, we do pretty well. And if you can get it down to 6, you can get a homeowner to make six payments, and we can set those up as automated payments to make it easy. But the sooner the better. And moving quickly should not be thought of as being aggressive, but it's being responsive. We're not going after these owners. We're informing them of their delinquency. We're educating them on their obligations and why they're important. And so while the litigation and foreclosure process is set up to be adversarial, we very quickly transition these files from a lawyer handling the matter to a paralegal who is trained in settling these cases and setting up payment plans. That's our goal every single time.
Adam, does it, is there a point where avoiding legal action is suitable? Meaning, if I operate under the assumption that, that maybe there's a $5,000 balance on a homeowner, hey, when they sell their home, they're going to make it right anyway. Is there a pitfall around that assumption that, at some point they've got to pay the association when they transfer the deed over and sell their home?
Yeah, because sometimes people decide to stay for a long period of time, and you can't predict when someone will sell their home. You can't predict how long they're going to be there. We do have associations that are just dead set against doing any kind of collection action. For whatever reason, they just don't want to make their neighbors upset, and they feel like people will pay whenever they get around to it. And for the most part, when the board wants to take some kind of action that's going to cost some money, associations that have that mentality very often don't have enough in the bank to fix important problems. They have deferred maintenance. They have sometimes they have private roads that are falling apart. Sometimes they have parks that you might get a call from CPS if you let your kids go play in them. And so it's just important to recognize that the lifeblood of an association is these assessments, and to fail to take any action is probably a breach of your fiduciary duty to the association, especially when the declaration includes your right to file a lien and foreclose. If you're not making the association take advantage of those rights, you're failing the rest of the members that, as I indicated before, are paying on time, every time, and without demand.
Is there a statute of limitations that comes into this? Is there a way that an association may not be entitled to collecting certain assessments or certain fees if a certain amount of time has passed?
That's a very good point. There's a 4-year statute of limitations on a debt to a homeowners association. So if, for instance, an owner owes $5,000 and they've owed it for 4 more years, those amounts that are 4 years or older drop off every single day. And so your ability to actually collect goes away, even if you file a lien. Even if this person ends up selling it 10 years down the road, you're going to lose all of those assessments, and they're going to get away with enjoying all the amenities of the community without ever having contributed their fair share. So that's a great point, and one that we have to deal with. Occasionally we'll get ledgers on delinquent accounts with amounts that are 6, 7, 8, 10 years old that the association hasn't bothered to try to collect in that period of time. And sometimes boards are pretty surprised to find out that they simply can't collect those amounts. Don't get yourself into that situation. Don't let these assessments go for that long. Certainly, if you're letting them go more than 6 months or a year, I think that's a problem. But if you get to the 4-year deadline, you really need to rethink your collection policies.
Thanks, Adam.
All right, so collection actions by a community association are governed by, first, the declaration, but also the Texas Debt Collection Practices Act and the Texas Property Code. Collection actions by a community association may also be affected by certain conditions or events, whether or not the property is the owner's homestead, if the owner is on active military service, or if the owner files bankruptcy. And so once a delinquency gets to our office, we do routinely a military service check. We check if the owner's filed bankruptcy, and we even check the probate records to make sure that there hasn't been a death in the family, or that the owner hasn't died in the middle of the proceeding. All right. The next C is covenants. You need to be aware of the covenants in your association, and on the board of directors, I think it should be a requirement that you read your declaration. The restrictive covenants regulate the use of a lot or a unit by its owner. Covenants are intended to preserve and protect property values and owners' peaceful enjoyment of their property. Owners expect you to enforce these on their behalf. They will tell you that's why they moved into the neighborhood, is because that they wanted to live under a set of rules that govern everyone. Covenants can generally be described as either mandatory covenants. So these impose obligations like maintaining landscape, maintaining property to a particular aesthetic level. And then you've got prohibitory covenants. And these are ones that impose an obligation to refrain from doing something. You may not park a boat in a driveway. You may not have a dog that creates a nuisance, those types of things. And so part of your job is to enforce these restrictive covenants. And we've got both non-judicial and judicial procedures. we try to use non-judicial procedures first. These have to be authorized by the community association's declaration. And these include self-help remedies. A lot of times we refer to a force mow, meaning we go and mow somebody's yard and send them a bill. But those self-help remedies extend further than just mowing someone's yard. We don't want to use those except in the most of extreme situations. But if somebody parks an 18-wheeler, say, in their front yard and refuses to move it, we can certainly go tow that thing and send them a bill. And then, of course, the assessment of fines. Not every single-family residential community is authorized to fine its owners. Check your declaration, make sure you've got the right to fine. But if you do, you should have a fine policy so that these fines are applied uniformly to the entire neighborhood. Now, we also have judicial enforcement, and this consists of filing a lawsuit against an offending owner for breach of their contractual obligations to comply with the covenant. And it can also seek specific performance of their obligation to comply. This usually includes an injunction. If it's a dangerous issue, this might include a temporary restraining order, ordering the owner to immediately cease and desist from undertaking the dangerous activity. If instead it's something like you need to remove your shed you built without permission, then we're probably going to be asking for a permanent injunction and going to court to get a judge to order them to comply. This is generally preferable in non-emergency situations over and above self-help remedies because the association will be requiring the owner to take the action themselves instead of entering into someone else's property, and it helps kind of keep the peace in the neighborhood. Now, judicial enforcement is subject also to an affirmative defense by a property owner, including a 4-year statute of limitations and also the defenses of abandonment and waiver. What this means is that if you discover that somebody is not complying with your deed restrictions, you need to take action within 4 years. My example of a shed is a good one because it comes up all the time. Sometimes we get what I like to refer to affectionately as the new sheriff in town board of directors. There's been lax enforcement for years and years. The new sheriff in town board wants to come in and clean up this one-horse town, but they find very quickly that these issues that they've been complaining about for years have been there for too long. And if you've got sheds that have been there for 5 or 10 years, you've got issues that have pre-existed your involvement, and they're older than 4 years, there's probably nothing that we can do to force an owner to comply. There are some creative solutions. I'll talk about that with anybody that wants to offline that has those issues in their neighborhood. You're not out of luck. You're just out of judicial enforcement options. The other affirmative defenses are abandonment and waiver. Waivers is pretty simple. It refers to a specific covenant. So if you've got a covenant that says no basketball goals, but a third of the neighborhood has basketball goals out and they've had them out for the last 5 years, you've probably waived the right to enforce that restriction. A good rule of thumb is about 10%. If 10% of the neighborhood is openly violating a particular rule or regulation and you haven't done anything about it in the last couple of years, you may be charged with having waived that particular covenant forever. Abandonment is a much more serious affirmative defense, and that's basically saying that by waiving the majority of the covenants in your restrictive covenants and declaration, that you've abandoned the whole thing. So you got to be careful about that. But on the same note, it's a pretty tough one to do unless your board has just been completely derelict. Now, both non-judicial and judicial enforcement procedures are subject to certain due process requirements before a community association can assess a fine, charge an owner for damages to the common area, file a judicial enforcement lawsuit, and that's only in a subdivision association, or suspend an owner's right to use the common area only in a subdivision association. And what that really means is that you simply have to send the required statutory notices to the owners. You have to give them a right to a hearing if they request one regarding a fine or a charge, and then you need to give them all of the information that you used to determine that they had violated your restrictive covenants. And so the final C of my 6 C's is community. Now, as a board of directors, you are the ambassador for the association to the community. And a community association combines the characteristics of local government, a business, and a community. And a strong sense of community among residents and clear lines of communication is essential to creating community spirit, encouraging active participation by residents in the community association, and building vibrant, responsive, and healthy communities. And Mitch said it at the beginning, and you'll hear me say it anytime you probably ever ask me a question. The biggest thing that I can encourage you to do is to be transparent. Operate in the light of day. The thing that creates the most turmoil in a community is secrecy, is operating without complete disclosure. And it's a good rule to think, hey, is the decision we're making right now something I'd be proud to tell my next door neighbor about? And if it's not, you should probably reconsider it. I get a lot of questions about attorney-client privilege and what should we take to executive session and what can we tell the community. My goal would be to tell the community everything. Tell them everything you're doing. I mean, there's certain confidential information that you're not permitted to share, like specific delinquency matters involving a particular owner, violation history of a particular owner. But besides those types of things, what you're doing as a board, what your plans are for the community, the money you're spending, those should all be readily accessible to the owners, because you can be doing all the right things, but if the community doesn't know about it, or they don't see where their money's going, or they think that you're hiding the ball, they assume the worst. And most of the time, I'll get involved in these situations. I'll be asked to review postings to Facebook or Nextdoor, and what should we do about this? It's almost always caused by a lack of transparency. So, on behalf of your communities, be transparent, operate in the light of day, and more often than not, I think you're going to be in good shape. Now, board members should always promote a high level of community involvement in terms of voting, meeting attendance, and volunteerism, promote transparency in the operation of the association, and promote resolution of disputes and issues in a neighborly manner. Sometimes you'll be asked to mediate between two owners, and doing so, while maybe not your legal obligation, can really lead to fostering a real sense of community and leadership. And it's why you volunteered, and it's hopefully why you're on the board.
Thank you for your time. And we got a couple minutes before the end of the call. If anybody has any questions, feel free to navigate to the chat screen and type those in. And if we don't cover your question, or if you'd like to dive deeper into it, I'll share my contact information in the recap email, but also wanted to make Adam's contact information available to you. Adam, any closing thoughts from you in terms of where they can reach you or how you can be helped?
Email me, call me anytime. I like to be a resource to boards. And one of the things that I always tell my clients is reach out with your questions. I would be surprised at this point if you've got a question about your association that I haven't answered for another association before. This area of the law is quite frankly kind of weird. And there's not a lot of us that specialize in it. But at the same time, I've navigated these issues before. So pick up the phone, call me, send me an email. It might take me 4 or 5 minutes to answer your question. If it doesn't, I'll let you know that we need to go on the clock, and we'll do some research and answer your question. But I bet 90% of the time I'll have an answer for you in 3 or 4 minutes as to what to do next. And it's not going to appear on a bill. I do get that a lot, that boards are very cost conscious. They don't want to engage a lawyer because they're worried about how much money it's going to cost. The landscaper decided to blow leaves at my window right this instant. But don't worry about those things. Before I start billing you, I'll let you know. And most of the time, it's pretty easy to answer your questions without ever starting the clock. So use my phone number, use that email address, and get your questions answered before you go off and potentially make a very expensive mistake that involves litigation and a long drawn out lawsuit.
Hey, Adam, quick question came in from Kay regarding the discussion on transparency. So anything, the question is, so anything other than delinquency or such legal, issues should be updated to the community, even if it's a closed board session? Thanks in advance.
Well, it just begs the question of why is the board session closed? I think workshops and meetings and talking about what's the budget going to be and planning for the annual meeting. These are things that have to happen. The board has to do them, and it doesn't necessarily need to be in an open board meeting. But if you're spending money for the association, if you're planning, capital improvement projects, if you're doing anything other than discussing ongoing litigation or collection matters, I think those should be available to the community. They should know what you're up to. There's just not a lot of instances where I can think of justifying secrecy. It's if you've got a question, ask me about it. I mean, there's certainly instances where we shouldn't be disclosing things to the association. Emails with me, for instance, those probably need to stay private. But ultimately, if we make a decision based on my advice, we can share what the decision is with the association, and even share that you asked the lawyer about it and got their opinion. So I just can't advocate for transparency enough. And even sometimes, communications with me have been disclosed that were helpful to the community. So there's an exception to every rule, and that's certainly one of them.
Some things that I would, encourage you to share. So balance sheet and an income statement would probably be a good thing to share month to month, just offering neighbors insight on what's going on. I wouldn't share the entire financial package, obviously, because there's information about receivables in there. But just generally speaking, how is the association performing financially? That's really helpful. Copies of contracts of the association is something that's a best practice to share. No reason to hide any of that. There are situations, a quarterly update from the board or from management or a combination of the two in terms of what you're working on is really, really helpful. Most people won't show up to a board meeting, no matter how hard you beg them to try. So, the beauty of TownSq is that you can go in and quickly post something. And as board members, you have the ability to do so. You can go and post a note and just say, hey, here are the kind of the 5 things that we're working on collectively over this month or this quarter. It reduces the noise out there. So oftentimes a lot of the stuff that makes it on the neighborhood Facebook page are things that homeowners just don't know that you're working on already, right? That you're addressing. So landscape is always a big part of that. Hey, why haven't the trees been trimmed? Well, just so you know, the trees are being trimmed, next month. And we've got that scheduled because our arborist told us that it's the best time to take care of the tree trimming, right? So, things like that go a long, long way in helping alleviate that noise. I think the big things are, and I'd always ask yourself, if I was a homeowner and not on the board, would I want to know this information? And I think that's kind of the rule of thumb, to Adam's point, is being fair in what's being disclosed. All right. I think that does it for the sake of time. I know we're over our time allotment, and I know Adam's got a bunch of things to get back to. So for those of you who submitted a question that wasn't answered, I'm going to go through and make sure that you get an answer. I'll also share a recording of this presentation on both our Facebook page. If you are interested in tuning into that, you can access it there. I'll also send you a link via email and the recap email, along with a copy of the slides used in today's presentation. Big thank you to Adam. Appreciate your time, man. Always very, very helpful. And thank you to each of you who've made time, taken time from work or from your day to just learn more about being a better board member. Thank you, thank you, thank you for taking the time to invest in us and the content today. So appreciate you all. Have a great day and look forward to connecting with you in the near future. Thanks. Thank you, Adam.
Thanks for having me, Mitch. Nice to see you all. Bye-bye.